Okay, we're back. Part 2, Book 3, Chapter 4. This certain place was established in Westminster Hall. And again, we're talking about the Court of Common Pleas, where the Aulus Regius originally sat when the king resided in that city. And there it is ever since continued. And the court being thus rendered fixed and stationary, the judges became so too. And a chief with other justices of the common pleas were thereupon appointed. This jurisdiction to hear and determine all pleas of land and injuries merely civil between subjects. Which critical establishment of this principal court of common law at the particular juncture of the particular place gave rise to the Inns of Courts in its neighborhood, and thereby collecting together the whole body of the common lawyers, enabled the law itself to withstand the attacks of canonists and civilians who labored to extirpate and destroy it. So since they set this court up in Westminster Hall, the lawyers gathered around there, I guess, to keep an eye on the canonists. The precedent was soon copied by King Philip of France, who about the year 1302 fixed the Parliament of Paris to abide constantly in that metropolis, which before used to follow the person of the king wherever he went, and of which he himself used frequently to decide causes that were depending, but all were then referred to the sole cognizant of the Parliament and its learned judges. And thus also in 1495, Emperor Maximilian fixed the imperial chamber, which before always traveled with the court of the household, to be constantly held at Worms, and once and afterwards translated to Spire. So to me it sounds like these courts are somehow in the Archbishop's diocese. Let's keep going. So the Aulus Regius being thus stripped of so considerable branch of its jurisdiction, and the power of the Chief Justicer being considerably curbed by many articles of the Great Charter. In the Great Charter, they're talking about the Magna Carta. The authority of both began to decline apace under a long and troublesome reigns of King Henry III, and as further pursuant of this examples of several officers of the Chief Justicer were under Edward I, who new modeled the whole frame of our judicial polity, subdivided and broken into distinct courts of judicature. So basically they took this thing called the entire King's Bench, and then they stripped it into different parts. So this is what they did. A court of chivalry was erected, over which the constable or marshal, military officer of high rank, presided, and did the steward of the household over another, constituted to regulate the king's domestic servants. The court of chivalry is a civil court. I think it's the court of common pleas. The high steward, with the barons of parliament, formed an august tribunal for the trial of delinquent peers, and the barons reserved to themselves in parliament the right to reviewing the sentences of other courts in the last resort. Delinquent peers, I think they're talking about tax time. An august tribunal. I don't know what that means. What is an august tribunal? The distribution of common justice between man and man was then thrown into so provident an order that the great judicial officers were made to form a check upon each other, and provident is for future needs or events, frugal and economical. So the Court of Chancery issuing out all original writs under the Great Seal to the other courts, the common pleas being allowed to determine all causes between private subjects, the Exchequer managing the king's revenue, and the court of the King's Bench retaining all jurisdiction was not cantoned out to the other courts, and particularly the superintendence of all the rest by way of appeal, and the sole cognizance of pleas of the crown, or criminal causes. So pleas of the crown go to the King's Bench. Chancery issues out original writs under the Great Seal. Common pleas is where you're going to hear cases between private subjects. So when you go to the Court of Common Pleas, it is a common law court. You're going there as a subject. You're a living man. They're going to get you to put your seal on something as a living man that has to do with this trespass. So you're going to acknowledge that you owe this debt on this statute staple. Put your seal on it, and the show continues. For pleas of suits are regularly divided into two sorts. Pleas of the Crown, which comprehended all crimes and misdemeanors wherein the king, on behalf of the public, is the plaintiff. So on the plea of the Crown, you are the plaintiff. And a plaintiff is a plaint in a civil matter. And common pleas, which are included all civil actions depending between subject and subject. So if you're just a subject, then go ahead and put their paperwork in. If you're the king and you're the plaintiff, then put in a plea of the Crown. So the former, which would be the pleas of the Crown, proper jurisdiction of the Court of the King's Bench, and the later, the Court of Common Pleas. So Common Pleas, which is the court of record, and is styled by Sir Edwin Coke the lock and key of common law, wherein only can real actions, that is, actions concern the right of freehold or of the realty. So the right of the freeholder, the copyholder, who has the copyhold by inheritance, or the realty, which in my opinion is you, being brought. And all other or personal pleas between man and man are likewise here determined, though on some of them the King's Bench has also concurrent authority. Now, what's realty? Abstract of real or distinguished from personality. Realty relates to land and tenements, rents, or other hereditaments. So the right of freehold or the right of land and tenements, rents, or other hereditaments is heard there. This is the court they have to take you to in order to access your inheritance. This is my words from last night as I was thinking about this. They will be filing a writ of trespass from the King's Bench that allows them to also charge for other public wrongs or private wrongs, like a statute merchant, they want you to acknowledge. And then from page 7 of this document, for in order to be entitled to sue an action of trespass for goods before the King's justices, that's what they're doing now, the plaintiff is directed to make an affidavit that the cause of action does really bona fide good faith amount 40 shillings, which affidavit is now unaccountable disuse except in the Court of Exchequer. If you don't find the affidavit, do a writ of error as a plea of the Crown. Something along those lines. Or just point it out, where is the affidavit that says the action bona fide good faith amount of 40 shillings? The judges of this court are at present 4 in number, 1 chief, 3 younger justices, created by the King's Letter Patent, who sit every day in 4 terms to hear and determine all matters of law arising in civil causes. Subject on subject, whether real, personal, mixed, or compound, or both. These it takes cognizance of, as well originally as upon removal from the inferior courts before mentioned. So all those littler courts before would be appealed to this court. But a writ of error in the nature of an appeal lies from this court to the Court of the King's Bench. All right. We had a writ of judgment before, I think it was called, that would take it to this one. And if you don't agree with this one, you go by writ of error to the King's Bench. The Court of the King's Bench, so called because the king used to formally sit there in person, the style of the court being before the king himself, is the Supreme Court of Common Law of the kingdom, consisting of a Chief Justice and 3 younger justices, who are by their office the sovereign conservators of the peace and supreme coroners of the land. Supreme coroners of the land. Common law coroner back in the day when they did this was the keeper of the king's pleas and protector of his property. And we're submitting our pleas of the crown into this court, so they must be the keeper of the king's pleas. Well, they're also protecting your property. Right now, they're just protecting it from you. Yet though the king himself used to sit in this court and is still supposed to do so, he did not. Neither by law is he empowered to determine any cause or motion, but by the mouth of his judges, to whom he has committed his whole judiciary authority. Last week we heard Jason's friend here in court after putting a plea of the crown. You are free to go. Didn't say come back, he got another hearing date. You are free to go. This court, which we have said is a remnant of the Alua Regia, is not nor can be, from the very nature and constitution of it, fixed to any certain place, but may follow the king's court, wherever it goes. For which reason all processes issuing out of this court in the king's name is returnable wherever we are in England. So wherever you are, when you do a plea of the crown, it's good anywhere in England. Wherever we are in England, it's still a plea of the crown to the king's bench. It's supposed to follow you. You're the king. It was indeed, for some centuries past, usually sat at Westminster, being an ancient place, the crown, but might remove to the King of York or with the King of York or Exeter, if he thought proper to command it. And we find that after Edward I had conquered Scotland, it actually sat at Roxburgh. And this movable quality, as well as its dignity and power, are fully expressed as Bracton when he says that the justices of this court are, remember there's 4 of them, you got a chief, a general, a perpetual, and an elder, accompanying the king, who are appointed to redress injuries and correct the errors of all others. Chief Justice and 3, so, it said a couple pages up, Chief Justice and 3 other justices. 1 chief, 1 general, 1 perpetual, 1 elder. And these are the justices of the king's bench, the sovereign coroners, in my opinion, the ones that sit in probate. It is moreover especially provided in the articles upon the charters that the king's chancellor and justices of his bench shall follow him, so that he may have at all times near unto him some that be learned in the laws. So the king's chancellor and the justices of the king's bench. Now the king's chancellor is over the exchequer. He's also over the court of chancery. The jurisdiction of this court is very high and transcendent. It keeps all inferior jurisdictions within the bounds of their authority, and may either remove their proceedings to be determined here, or prohibited their progress below. So they can either, by appeal, they can either, because it's unlawful, change it, or send them down a writ of mandamus to the lower court to do something. Habeas corpus, whatever it is. It superintends all civil corporations, and we'll go to the definition page in a minute, in the kingdom. It commands magistrates and others to do what their duty requires. In every case where there is no other specific remedy, it protects the liberty of the subject by speedy and summary interposition. It takes cognizance both criminal and civil causes, and former in what is called the crown side, or the crown office, later in the plea side. Okay? So on the crown side it was criminal. In the plea side it is civil, and we're putting in a plea of the crown. Let's go look at civil corporations. Here's another interesting frickin' definition. Just here are parts of it. So, nations or states are denominated by publicist bodies politic and are said to have their affairs and interests and to deliberate and resolve in common. They thus become as moral persons having an understanding and will peculiar to themselves. See, a moral person, I think they're saying as a man. In the law of nations, they use the word moral person. I believe they're talking about a man. have an understanding with peculiar and will peculiar to themselves, and are susceptible of obligations and laws. So you have free will. In this extensive sense, the United States may be termed a corporation, and so may each state singly. So by this here, they're saying that you are a corporation. What kind of corporations are there? You got private corporations. And popular meaning of the term, nearly every corporation is public, inasmuch as they are created for the public benefit. But if the whole interest does not belong to the government, or if the corporation is not created for administration of political or municipal power, the corporation is private. A bank, for instance, may be created by a government for its own use, but if the stock is owned by private persons, it's a private corporation. Although it is created by the government and its operations partake of a private nature. Sounds like the Federal Reserve. And the same in case of a canal, bridge, turnpike, insurance companies, and the like. Charitable or literary corporations founded by private benefication are, in point of law, private corporations, though dedicated to public charity or the general promotion of learning. Private corporations are divided into ecclesiastical and lay. Ecclesiastic corporations in the United States are commonly called religious corporations. They are created to enable religious societies to manage with more facility and advantage the temporalities belonging to the church or congregation. They're managing your estates, is what they're talking about. Lay corporations, again, these are private, are divided into civil and elomasonary. Civil corporations are created for an infinite variety of temporal purposes, such as affording facilities for obtaining loans for money, making of canals, turnpikes. So that makes it a civil corporation, and that's what this court has jurisdiction over. Right? They're talking about them for those. That's the kind of civil corporations they have. Eleemosynary corporations are such as instituted upon principle of charity, their object being the perpetual distribution of the bounty of the founder of them to such persons as he has directed. Of this kind are hospitals for the relief of impotent, indigent, deaf, dumb. They're talking about you. This is the kind of corporation they have you at, that the object being the perpetual distribution of the bounty of the founder of them to such persons as he has directed. Well, right now we've directed them, and we want to stop doing that. But so the King's Bench superintends all these. I don't know exactly what that means yet, but I think we could use it once we understand it better. It commands magistrates and others to do what their duties require. That'd be a writ of mandamus. In every case where no other specific remedy, it protects the liberty of the subject by speedy and summary interposition. It's going to get in the middle of it immediately if you bring a plea of the Crown in. It takes cognizance of both criminal and civil causes. We already talked about that. The former Crown side, the latter plea side, and we're in the plea side. The jurisdiction of the Crown side criminal is, we're not interested in that, as it be talked about in Book 4. But on the plea side, or civil branch, it has original jurisdiction and cognizance of all trespasses and other injuries alleged to be committed by force of arms, which, being a breach of the peace, favor a criminal nature, although the action is brought for a civil remedy, and for which the defendant ought, in strictness, to pay fine to the king as well as damages to the injured party. So, on the plea side, it has original jurisdiction for all trespasses. Okay, they're going to go get a writ of trespass. Although the action is brought for a civil remedy, and for which the defendant ought in strictness pay a fine to the... Okay. This court might likewise, upon division of, have originally plead any other civil action whatsoever, except actions real, which are new and very seldom used, provided the defendant was an officer of the court, or in custody of the marshal, or prison keeper, or court, for breach of peace, or of any other offense. Well, they have you in custody of a marshal right now, through the way the system's set up, so you're always in custody. have originally held plea of any other civil action whatsoever. So the defendant was an officer of the court, or in the custody of the marshal, a prison keeper of this court, for a breach of the peace or any other offense. In process of time, by a fiction, this court began to hold plea of all personal actions whatsoever, and continued to do so for ages, it being surmised that the defendant is arrested for a supposed trespass, which he never has in reality committed. And being thus in the custody of the marshal of the court, the plaintiff is at liberty to proceed against him for other personal injury. Statute staple, statute merchant. The dude owes me money. I got a bond with him. As soon as you get him to sign it. Which surmise of being in the marshal's custody, the defendant is not at liberty to dispute. Well, they're saying we're under this marshal's custody, so we really can't dispute it. The guy brings the claim, we have to go defend it. And these fictions of law, though at first they may startle the student, he will find, upon further consideration, to be highly beneficial and useful, especially as this maxim is ever invariably observed, that no fiction shall extend to work and injury. So a fiction can't bring an injury. When you look at your writs that they use on you, on their paperwork, they're using a fiction. Well, they can't do that. Its proper operation being to prevent mischief or remedy an inconvenience that might result from general rule of law. So you point out that they're doing it with a fiction. Again, I don't know the exact paperwork to use. I'm just pointing out what we might use, and somebody think about it. How are you going to put this into that no fiction shall extend to work and injury? All right? Plea of the crown. So true is it that all legal fictions are founded in equity. So all legal fictions are founded in equity. In the present case, it gives the suitor his choice of more than one tribunal before which he may institute his action, and prevents the circuitry and delay of justice by allowing that suit to be originally, and in the first instance, commenced in this court, which after determination in another might ultimately be brought before it on a writ of error. So since it could be tried someplace else, you can try it in this court. And that's where they're going to. They're going to their writs are under the seal of the court of record of the county. That is the King's Bench, or part of it. They're not going to the Court of Chancery to get an original writ. They're going the other way. But to do this, they have to say the case, they have to put in an affidavit saying the case is 40 shillings. Go find the affidavit. I don't think you're going to find it. For this court is likewise a court of appeal, into which may be removed by writ of error all determination of the Court of Common Pleas. All right, so anything in the Court of Common Pleas by writ of error can be taken to the King's Bench, and all inferior courts of record of England. So all of them can be taken to the King's Bench, and to which writ of error lies also from the Court of the King's Bench in Ireland. Yet this is so high and honorable court is not the last resort of the subject. For if he is not satisfied with the determination here, he may remove it by writ of error into the House of Lords or the Court of Exchequer Chamber, as the case may happen, according to the nature of the suit and the manner in which it has been prosecuted. So we need to know the nature of the suit, how it's been prosecuted. We either go to the King's Bench, the House of Lords, the Court of Exchequer, with a writ of error. So I'm going to write 3 writs of error and take them to each of them. So we need to find out, brother, I'd like to know where the House of Lords is. Or I want to know where the Court of Exchequer Chamber is. Because that's next. The Court of Exchequer is inferior in rank not only to the courts of the King's Bench, but also the Common Pleas. And the reason it's inferior is before there can be equity, which is the Court of Exchequer, it must be lawful, because equity follows the law. First it has to be lawful, then there can be equity. But I have chosen to consider it in this order on account of its double capacity as a court of law and a court of equity also. In very ancient court of record set up by William the Conqueror as part of the King's Bench, although regulated and reduced to its present order by King Edward I, and intended principally to order the revenues of the crown and to recover the king's debts and duties. the taxman. It is called the exchequer, from the checkered cloth resembling a chessboard which covers a table there, on which there are certain of the king's accounts are made up, and sums are marked and scored with counters. All right, they're keeping score. It consists of two divisions. Again, you got two things, right? You have one thing that has two possibilities. That's logic. Input makes it go one way or the other. It consists of two divisions. The receipt of the exchequer, which manages the royal revenue, and which the commentaries have no concern. Right? The receipt of the exchequer. So that's its one division. That's the taxman. And the court or judicial part, which is again subdivided into a court of equity and a court of common law. So we want one down one way. That doesn't interest us. We get on this other way. Now it has two possibilities. Subdivided. You got a court of equity and a court of common law. Well, the court of equity is held in the exchequer chamber before the Lord Treasurer, the Chancellor of the Exchequer, the Chief Baron, and three justices. Is that a six-man panel? I don't know. I got to ask them. Where is the Exchequer chamber? I want to see the court of equity for the Exchequer chamber, held in the Exchequer chamber. And some dude, Mr. Selden, conjectures to have anciently been made out of such were barons of the kingdom and parliamentary barons, and thence have derived their name, which conjecture receives great strength from Bracton's explanation of Magna Carta, which directs that the earls and barons were amerced by their peers, that is, says he, by the barons of the exchequer. Well, what is amerced? Law, to punish by fine imposed arbitrarily at the discretion of the court, to punish by imposing an arbitrary penalty. Sounds like a tax to me. It's just arbitrary. The primary original business of this court is to call the king's debtors to the account to be by bill filed with the Attorney General. So all this paperwork that the prosecutor's putting in, he's doing as the Attorney General. He's filing the bills that have been brought to him, and recover any lands, tenements, hereditaments, any goods, chattels, or other profits or benefits belonging to the crown. So that by their original constitution, the jurisdiction of the courts of common pleas, King's Bench, Exchequer, were entirely separate and distinct, the common pleas being intended to decide all controversies between subjects, the King's Bench to correct all crimes and misdemeanors that amount to a breach of the peace, and where the king being the plaintiff, as such offenses are in open and derogation of the royal rights of his crown, and the exchequer to adjust and recover his revenue, wherein the king is also a plaintiff, as holding, withholding, and non-payment thereof is an injury to his royal revenue. So in both cases, the king is the plaintiff. We're the plaintiff. But as by fiction almost all sorts of civil actions are now allowed to be brought to the King's Bench, in like manner, by another fiction, all kinds of personal suits may be prosecuted in the Court of Exchequer. Right? So by the use of a fiction, we have one way to do it in the King's Bench, and we have another way to do it in the Court of Exchequer. For as all officers and ministers of the court have, like those of other superior courts, the privilege of suing and being sued only in their own court, also the king's debtors, the farmers, and all accountants of the exchequer are privileged to sue and plead all manners of persons in the same court of equity that they themselves are called into. So who's the king's debtor? Who's the farmer? The farmer's the guy that has the tenant that has a lease on your land, and all accountants of the exchequer. They have likewise privilege to sue and plead one another or any stranger in the same kind of common law actions, where the personality only is concerned, as are prosecuted in the courts of common pleas. Now this is what they're doing in the exchequer court. Personality also signifies what belongs to the person, as in personal property, where personal property only is concerned. So they have likewise privilege to sue and plead one another or a stranger in the same kind of common law actions. where personal property is concerned, as are prosecuted in the Court of Common Pleas. This gives original to the common law part of the jurisdiction, which was established merely for the benefit of the king's accountants, and is exercised by the barons only, the exchequer, and not the treasurer or chancellor. So for this common law side of their jurisdiction, we need to find the barons. The barons are the freeholders in the exchequer. And then you take to them what's you've been charged with and ask them if it's lawful. They follow the law. They're not going to follow the statute. So the writ upon which all proceedings here are grounded are called quoruminous, which is the plaintiff suggests that he is the king's farmer or debtor, and that the defendant has done him an injury or damage complained of, by which he is less able to pay the king's debt or rent. So they've gone in as the plaintiff and just suggested that he's the king's farmer or the debtor. He's one or the other. And that the defendant has done him an injury or damage complained of. So he's saying that he has a lease on your property, that he's the copy holder. Now he would be the copy holder. He would be this copy holder for lives. He's saying that he's got a copy of a title to your property. Well, you have a copy of this inheritance. This is a title deed being a copy of a record. You have one that shows that you are. So who has the superior title, you or them? That would be the certified copy or record of live birth, in my opinion. The one I put online before that has the big ass gold seal on mine. I got it at the age of 5. And to me, it shows that this copy hold of inheritance was set up and that the dude owes me rent. It's a copy hold. But I have the superior title. He's just a leaser to me. And these suits are especially directed by what is called the Statutes of Rutland to be confined to such matters only special concern of the king or his ministers of the exchequer. So I don't know what the Statutes of Rutland are, but maybe somebody else does and can post something on what those are. And by the something or other is enacted that no common pleas be henceforth held in the exchequer contrary to the form of the Great Charter. Okay, so the only ones they can bring have to go along with the Statute of Rutland. And they're confined to such matters only as especially concerns the king or his ministers of the exchequer. And is enacted that no common pleas be henceforth held in the exchequer contrary to the form of the Great Charter. But now, by suggestion of privilege, any person may be admitted to sue in the exchequer as well as the king's accountant. So it used to be just the king's accountant could do this. Well, now anybody can. And summarize being a debtor to the king is therefore become matter of form and mere word of course. And the court is open to all nations equally. So in my opinion, when they bring it in, they're saying that they're the debtor to the king. But they're not saying that we're the king. They're saying that we're keeping them from paying the king's bill. Well, I think we tell them, no, we are the king. Go ahead and pay it. The same holds with regard to equity side. Now we're going to go to the equity side of the court. For there, any person may file a bill against another upon bare suggestion that he is the king's accountant. So he's going to say that he's the king's accountant. But whether or not he is never controverted. It's never argued. So when they bring in this bill, which is the statute staple, in my opinion, they're saying that they're the king's accountant. We need to argue this was in one of the other parts I did, and we need to argue or demand to see their franchise that we gave them to make them a king's accountant. In this court on the equity side, the clergy have long used to exhibit their bills of non-payment of tithes, in which case the summarize of being the king's debtor is no fiction. So the clergy have long used to exhibit their bills for the non-payment of tithes. This would be very interesting to go look at for that reason. In which case the summarize of the being the king's debtor is no fiction, they being bound to pay him their first fruits and annual tenths. But the Chancery has of late years obtained a large share of this business. So it sounds to me like every year they bring you a check and they put in a bill, but we never go and claim it as the king, because they are the king's debtor, and so they submit a bill, and they are bound to pay him their first fruits and annual tenths. And there's actually a court set up called the Court of First Fruits and Tenths. An appeal from equity side of this court lies immediately into the House of Peers. But from the common law side, in pursuance of a statute, a writ of error must first be brought into the Court of Exchequer Chamber. So first you got to go to the Court of Exchequer Chamber. And from their determination, there lies, in the last resort, a writ of error to the House of Lords. So an appeal from the equity side of this court lies immediately to the House of Peers. So if you're coming with the equity side, you do that. But if you're coming with the common law side, a writ of error must first be brought into the Court of Exchequer. And I think that writ of error you're going to get from the Chancellor under his Great Seal. See, I think when we go to Chancery Court, we need to find out where the Chancery Court is. We need to tell them we need a writ of error. They already have these things written up, how they're supposed to be done, in my opinion. They're just going to give it to you under their seal. That becomes your the foundation of your suit. Okay, the High Court of Chancery is the only remaining in matters of civil property, by much and most important of any, the King's Superior and Original Courts of Justice. So, High Court of Chancery is the only remaining, and in matters of civil property, by much the most important of any, of the King's Superior and Original Courts of Justice. And we're dealing with civil. It has its name of Chancery from the judge who presides there, the Lord Chancellor, who Sir Edwin Coke tells us is termed somebody for cancelling the King's letter patents when granted contrary to law, which is the highest point of his jurisdiction. So these King's letter patents are things they've gotten you to sign. But when they've been granted contrary to law, under threat, duress, things like that, he has the ability to terminate them. And that's what's happened in all these civil cases, right? They've gotten you to sign something by duress, by fraud, by whatever. You bring it to his attention. But the office and name of the Chancellor, however derived, was certainly known to the courts of Roman emperors, who originally, it seemed, to have signified a chief scribe or secretary, who was afterwards invested with several judicial powers and general superintendency over the rest of the officers of the prince. So this dude is over all the other officers. The Lord Chancellor is the general superintendency over the rest of the officers of the prince. From the Roman Empire, it passed to the Roman Church. Ever Emolus of the imperial state, and hence every bishop has to this day his chancellor, the principal judge of his consistory. So you got an archbishop who's got a diocese, he's got a principal judge. And when the modern kingdom of Europe was established upon ruins of the empire, almost every state preserved its chancellor, and with different jurisdictions and dignities according to their different constitutions. So he could have different jurisdictions and dignities, but in all of them he seems to have supervision of all charter, letter, and such other public instruments of the crown, as were authenticated in a more solemn manner. And therefore, when seals came into use, he had always the custody of the king's great seal. This is the Chancery Court, under the Lord Chancellor. So that the office of Chancellor, or Lord Keeper, whose authority is declared to be exactly the same, is with us at this day, created by the mere delivery of the king's great seal into his custody. Whoever has the king's great seal is either the Chancellor or the Lord Keeper, whereby he becomes, without writ or patent, an officer of greatest weight and power of any now subsisting in the kingdom, and superior in point of presidency to every temporal lord. So the freeholders are temporal lords. But by delivery of the king's great seal into his custody, whereby he becomes, without a writ or patent, an officer of the greatest weight and power, we give him the power to be our power. He is Privy Councillor by his office, and according to the Lord Chancellor Ellesmere, Procurator of the House of Lords by prescription. To him belongs the appointment of all justices of the peace throughout the kingdom. Whoever's appointing the justices is this dude. I think it's Chief Justice Probate. Being formerly usually an ecclesiastic, okay, so they used to be an ecclesiastic, for none of them were capable of office or conservant writings, and presiding over the royal chapel. So where's the royal chapel? I think that's you, that's your earthen vessel, because they preside over it right now. He became the keeper of the king's conscience. So he's keeper of your soul, your spirit. That's how they split your Trinity. Visitor in the right of the king, of all hospitals and colleges, the king's foundation, and patron of all kings living under the value 20 per annum in the king's books. All kings' livings under the value of 20 per annum in the king's books. Well, we never have anything in there for us. Anyways, a procurator is a presiding officer, prescription. Presiding, he becomes the Lord's visitor, the right of the king, Lord to say prescription. He belongs to the appointment of all just peace, formerly ecclesiastic or capable. He becomes keeper, visitor, hospitals, patron of all kings. Where was prescriptions? Procurator of the House of Lords by prescription. Well, what's prescription? The process of acquiring title to property by reason of uninterrupted possession of specified duration, also called a positive prescription. Limitation of time beyond which an action, debt, or crime is no longer valid or enforceable. That's a negative prescription. All right. It becomes the procurator, the presiding officer, by prescription. It must be by acquiring title or property by reason of uninterrupted possession of specified duration, and also positive prescription. And patron, King's Foundation, he's the patron of all kings' livings under the value of 20. He who has dispossession and gift of an ecclesiastic benefice in Roman law signified the former's master of a freedman. All kings' livings under the value of 20. So I think that's what these freedmen are. They're not accessing their account. They're these copy holders by inheritance, and so that they're kings' livings under the value of 20. So they're poor kings, basically. This makes them their patron, or this makes him their master. He is the general guardian of all infants, idiots, lunatics, and has general superintendence of all charitable uses in the kingdom. And all this over and above the vast and extensive jurisdiction which he exercises in his judicial capacity in the Court of Chancery, wherein, as in the Exchequer, where there are two distinct tribunals, the one ordinary, so exercises his judicial capacity in the Court of Chancery. All this over and above the vast, extensive jurisdiction which he exercises in his judicial capacity in the Court of Chancery. Now we're going to get into what that is. As in the Exchequer, there are two distinct tribunals, the one ordinary being the Court of Common Law, the extraordinary being the Court of Equity. So, in the Court of Chancery, got two distinct tribunals. One is ordinary, being a Court of Common Law. The other is extraordinary, being the Court of Equity. The ordinary legal court is much more ancient than the Court of Equity. The jurisdiction is to hold plea upon show cause, to repeal and cancel the king's letters patent, so show cause why they should have what they have. If they can't, then repeals the letters patent when made against the law, or upon untrue suggestions, like somebody said that they were the king's accountant, as it said above, and to hold plea of petitions, showing of right, writs of right, traverses of officers, and the like, and when the king has been advised to do any act or is put in possession of any lands or goods in prejudice of the subject's right, on proof of which the king can never be supposedly intentionally to do any wrong. The law questions not, but he will immediately redress the injury, and refers the conscientious task to the chancellor, the keeper of his conscience. It also appertains to the court to hold plea of all personal actions, where any officer or minister of the court is a party. It might otherwise hold plea on partitions of lands in co-parency, more than one owner, or more than one title. That's what we have now. We got multiple title holders. And of dower, where any ward of the crown was concerned in interest. Well, we're a ward of the crown right now. So long as military tenures subsisted, and it now may also do of tithes of the forest land, were granted by the king and claimed by a stranger against the grantee of the crown. Were granted by the king and claimed by a stranger against the grantee of the crown. Well, you're the grantee of the crown. So the King of Kings granted it to you, and it's claimed by a stranger against the grantee of the crown. Well, who's got the superior title? The grantee does. And of execution of statutes in recognizant and natural, in nature, therefore, by the statutes, whatever. I wish I knew how long this thing had been going. Well, we're going to try to finish this page. I might stop. But in any cause comes to issue in this court, that is, if any fact be disputed between the parties, the chancellor cannot try it, having no power to summon a jury, but must deliver the record by his own hand into the court of the king's bench, where it shall be tried by the country, and judgment shall be given thereon. So, but in any cause comes to issue in this court. So the whole idea is you need to get something to come to issue. Everything is disputed facts, and you need to get it down to an issue, which is yes or no. So, but if any cause comes to issue, that is, in fact, be disputed between the parties, the chancellor cannot try it, having no power to summon the jury, but must deliver the record by his own hand into the court of the king's bench. And I think this is when they leave the court, when they call a recess, they take your file back normally, and they take it into the common law side, fictitious jury, all the crazy stuff they do. But we can use it also. And when judgment is given in chancery upon demurrer or the like, a writ of error in nature of an appeal lies out of this ordinary court into the court of King's Bench. Though so little is usually done on common law side of the court, that I have met no traces of any writ of error being actually brought since 14th year of Queen Elizabeth, 1572. I have met with no traces of any writ of error being actually brought. I think he's saying that's what we should do. What they've done is hid it from us, and we haven't done it. So he does have this court of common law, right? And if you go to the chancellor, he can take care of everything. And the court of chancery is always open. In this ordinary legal court is also kept the storehouse of justice, out of which all original writs that pass under the Great Seal. So that when they talk about getting these original writs under the Great Seal, they're talking about going to the common law side of this court, the court of chancery, out of which all original writs that pass under the Great Seal, all commissions of charitable uses, sewers, bankruptcy, idiocy, lunacy, and the like, do issue, and for which there is always open to the subject, who may there at any time demand and have, as due to justice, any writ that his occasion may call for. So I think you go there and you tell them what your problem is, and they give you the writ under the Great Seal for you to pursue your case. These writs relating to the business of the subject and the returns of them were, according to the simplicity of ancient times, originally kept in a hamper, and the other relating to matters wherein the crown is immediately or immediately concerned. So you got one that's the business of the subject, those are kept in the hamper, and the one where the king's involved were preserved in a little sack or bag, and hence has arisen the distinction of the hamper office and the petty bag office, which both belong to the common law court and chancery. So find the common law court and chancery, go to the petty bag office. That's where you should find these writs, in either that they put in or that we need to have. That's where these would come out under the Great Seal. Right? They were supposed to go, because they're dealing with the king, to the petty bag office to fill out their writ. Should be have a copy of it there. But the extraordinary court of equity has now become the court's greatest judicial consequence. So that was the common law side. Now we're going to talk about the equity side. And again, this is the chancery court under the chancellor. This distinction between law and equity as ministered in different courts is not as present known or seems to have been known in any other country at any time. And yet the difference of one from the other, when administered by the same tribunal, was perfectly familiar to the Romans. Well, go figure. But the power of both centered in one and the same magistrate. So you got one guy that has power in both, who is equally entrusted to pronounce the rule of law and apply it to a particular case by principles of equity. First, it needs to be lawful, then he can apply equity. With us too, which was the superior court of judicature, undoubtedly administered equal justice according to the rules of both or either, as a case might chance to require, and when it was broken into pieces, the idea of the court of equity, as distinguished from the court of law, did not subsist in the original plan of partition. So equity and law were always supposed to be together. They were not supposed to be distinguished from each other. It's just first the gentleman decided if it was lawful. If it did, then he could apply equity. You got to get it lawful. Did they break the law? Yes or no? That's really all common law is. Did you break the law? Will you confess, guilty or not guilty? Yes or no? Let your yea be yea, let your nay be nay. For though equity is mentioned by Bracton as a thing contrasted to strict law, and yet neither in that writer nor Glavenfeld and these other guys composed any auspices, is there a syllable to be found relating to equitable jurisdiction of the court of chancery. So nowhere is it written that they have this. Yet they do, because the idea was never to separate them. If you have common law, you have equity. Okay, I'm going to stop here, and hopefully we can finish this up on the next one. At least I'll see how much time I got left. How long? Yeah, 55 minutes. I got to stop this one. See y'all.